This video is a complete UK spouse visa requirements guide for 2026, including applications made from inside and outside the UK, as well as extensions. As an immigration advice authority regulated UK immigration law firm that has helped more than 5,000 partners obtain their UK partner visas, we are exceptionally well placed to discuss this. Just so you know that this video is relevant to you, let's discuss what we mean when we refer to UK spouse or partner visas. This is particularly important because there are different types of partner visas which all have different requirements. We often see questions about UK dependent visas in the YouTube comments, but these are different from UK spouse and partner visas. A UK spouse visa is only for those whose partner is either a British or Irish citizen, a holder of indefinite leave to remain or settled status, or is one of the following. If the partner has a temporary visa, or a visa which has a time limit, such as a skilled worker visa, the applicant should apply as a dependent, not a UK spouse or partner visa. The spouse visa lasts 33 months if applying from outside the UK, and 30 months if applying from inside the UK. We'll also explain whether you'll be applying from inside or outside the UK, so no need to worry if you're unsure. A UK spouse visa can lead to indefinite leave to remain, and then later British citizenship. And a UK spouse visa allows full work rights, unlike a fiancé visa, which does not. We discuss this further on our website www.migrate.org.uk. Are we applying from outside or inside the UK is one of the most common questions we get. It's an important distinction as the process, requirements, and fees all changed based on where the application is made. Let's break this down. If the applicant is in the UK as a visitor, they should return to their home country or a country where they hold any type of long-term residency to apply there. To apply from inside the UK, the applicant must hold a visa valid for more than 6 months, unless they're on a fiancé or proposed civil partnership visa, which are exceptions and can apply from inside the UK. So common visas which allow making an in-country application include UK spouse or partner visas, UK fiancé or proposed civil partnership visas, Tier 1 visas, Tier 2 visas or skilled worker visas, Tier 4 long-term student or graduate visas, Tier 5 visas including youth mobility scheme visas. Some may wonder, what if the UK partner, the sponsor, helps with the form, gathers the documents and uploads everything, as is most commonly the case? This does not change who the applicant is or where the application must be made. It is vital to understand the requirements before applying. This is because in most cases, the requirements must be met on the day the application is submitted. We will start by discussing the relationship requirements. The first relationship requirement is that the applicant must meet the immigration rules definition of a partner. The applicant qualifies as a partner only if they're a married partner, a civil partner, a fiancé or proposed civil partner, or an unmarried partner. The only difference between married or civil partners and unmarried partners is the documentation required. Married or civil partners must provide a marriage or civil partnership certificate, which if it's not in English or Welsh must be translated. And unmarried partners, on the other hand, must instead show that they've been in a relationship with a sponsor that is similar to marriage or civil partnership for at least 2 years. All other requirements and the visa's terms are the same. Cohabitation can be a very effective way to prove this, but as we explain in our video on unmarried partner visas, it's not strictly required. If you're married or in a civil partnership when applying, it must be legally valid under the laws of the country where it occurred. For example, a marriage in Spain is acceptable if Spanish law recognises it. The second relationship requirement, as previously discussed, is that the sponsor of the application, also known as the UK partner, must be 1. A British or Irish citizen, 2. Present and settled in the UK, or one of the following. The third requirement is that the applicant and sponsor must be a genuine and subsisting relationship. So yes, you are required to prove that the relationship is genuine. The Home Office will assess the whole application to decide if the relationship is genuine and ongoing. They'll review the evidence, consider key relationship factors, and judge how they apply to your application. We'll begin with the factors of a genuine relationship, according to the Home Office, then cover common concerns, interviews, and how this requirement applies to visa extensions. The first point to know is that, unlike the financial requirement which follows clear rules, the genuine relationship test is subjective. It depends on how the Home Office caseworker views your relationship. The genuine relationship test applies to all partner visas. But if applying as an unmarried partner, as briefly mentioned, there's an extra rule. You must show that the relationship has been like a marriage or civil partnership for at least 2 years. We discussed this additional unmarried partner visa requirement further on our website, migrate.org.uk, and in a separate YouTube video. One factor in determining a genuine and subsisting relationship is its length. For those applying as a married or civil partner or for a UK fiancé visa, there is no fixed rule. You don't need to have known each other for a year or two before applying. Many couples will have known each other for over a year before applying, but in some cultural and religious traditions, it's normal to have known each other for a shorter time before applying. For married or civil partners, there is no rule about how long you must wait until after the ceremony to apply. It's actually quite common to apply soon after getting married or entering the partnership, even the day after marriage. If you apply shortly after marrying or entering into a civil partnership, wait to book the visa centre appointment until you have the certificate. As explained in our visa process article, documents don't need to be submitted on the same day the online application is submitted. One key factor of a genuine relationship is cohabitation before applying, but not living together before applying isn't necessarily a problem. In fact, it's common, especially for out-of-country applications for married, civil or fiancé partners, to not have cohabited, often due to visa limitations. Furthermore, Home Office caseworkers are told to consider cultural norms. If the applicant or sponsor's culture doesn't allow cohabitation before the marriage or civil partnership, this should be factored in. For those applying as an unmarried partner, however, as we discuss on our website, migrate.org.uk, some partners who have not cohabited may struggle to apply as an unmarried partner without prior cohabitation. Having children is one of the biggest factors of a genuine relationship. It's rare for an application to fail this requirement if children are involved, but not having children won't count against you. Other signs of a genuine relationship include shared finances, like joint bank accounts, bills, or insurance, and visiting each other's home country or family. Now, let's look at common concerns about meeting the genuine relationship requirement. If the applicant or sponsor had previous marriages or civil partnerships, this must be disclosed. But it's rarely a problem. Rather, in addition to evidencing this in accordance with the immigration rules, which we'll mention shortly, you just need to ensure that there's no reason for the Home Office caseworker to believe that any prior relationships are ongoing. As mentioned earlier, cohabitation helps show a genuine relationship. But for many couples, and in particular out-of-country applications, the relationship is mainly or entirely long distance. That's common and understood. The online form will ask if you live together, and if not, why. Most partners should not be put off by this, especially if it's an out-of-country application. It's a common situation as this is often due to visa limits, work or study conditions. Cultural or religious reasons also matter. In some cases, the relationship may not be accepted or even legal in the applicant's home country. If the relationship is long distance, show that living apart is temporary and the relationship remains strong and ongoing. While not living together isn't usually a problem, extra care may be needed if you've met only once or twice briefly. If that's the case, explain why, whether due to visas, distance, or culture. These things can matter. Age difference is another common concern. We handle partner visas daily, it's all we do. Large gaps like 25 years aren't too unusual, but this may require stronger evidence to show that the relationship is genuine. Another common concern is having a negative immigration history. This can raise red flags in cases where the applicant has overstayed or worked illegally. There has been a recent visa refusal, such as a skilled worker visa, especially before an in-country partner visa application. There is a history of sham marriage allegations involving either partner, or if the sponsor has supported multiple different partner visa applicants in the past. Each case depends on its facts, but these issues may result in closer scrutiny. And it's important to note the suitability requirements, which we'll discuss, which may result in an automatic refusal. Inconsistent or conflicting information, whether in the current or past applications, can affect how the Home Office views the relationship. Discrepancies in personal details, timeline, or living arrangements may raise doubts and lead to closer scrutiny. Clarity and consistency are key here. So it's important to ensure that all information is accurate, consistent, and truthful. As noted earlier, the Home Office looks at both the relationship factors and your supporting documents. Many couples assume that more documents means a stronger case, but often much of what is submitted adds little or no value. For example, letters from friends or family, social media logs, and gift receipts rarely carry weight in an application. The strongest documents support key relationship factors we discussed earlier, like birth certificates of shared children, proof of cohabitation, and to a lesser extent, evidence of shared finances. One of the many things that we do for our clients is to advise not only on the best supporting documents to submit based on their exact circumstances, but also on documents which do not need to be submitted. Without knowing your exact circumstances, we would generally recommend including photos in the application. To obtain this, you can use Microsoft Word to import photos and then annotate each photograph with additional context, such as the date and location it was taken. Letters of support from both the applicant and sponsor are also valuable in many applications. Yes, the online form asks for things like when you met and when the relationship began, but still, it doesn't allow for much space to explain the development of your relationship, as well as other clarifications you'd like to make about the answers in the online application form. Letters of support let you fill in those gaps and address any concerns that the Home Office caseworker may have. If a lack of documents is due to culture or religion, this matters, as Home Office caseworkers are told to not assume that all relationships follow UK norms. They must also consider local customs. If cohabitation is only allowed after marriage, or if cultural norms exclude women from official documents, or if same-sex couples can't safely live together, these points should be clearly explained in your letter of support. If your application lacks relationship evidence, the Home Office may arrange for an interview to look deeper before making a decision. With that said, interviews are very rare. The vast majority of couples won't be asked to attend one. For partner visa extensions, the bar for proving the genuine and subsisting relationship requirement is lower. The key question is whether the relationship is still ongoing. The focus is on cohabitation, and to a lesser extent, shared finances. This is reflected in the fact that you'll be asked to provide 6 items of correspondence, which are essentially documentation addressed to one or both of you at the same address. If, when the time comes for an extension, you're not living together or did not live together for a significant period since the last grant of the partner visa, there must be a reasonable explanation for you living apart, like one partner moving temporarily for work or living with a family member to provide care. All things considered, the genuine relationship requirement rarely causes refusals. More often, issues arise from other areas, like the failure to show a previous relationship has permanently ended or not meeting the financial requirement, which we'll discuss later. The 4th, 5th, and 6th requirements are that you must have met in person, both be at least 18 when applying, and intend to live together permanently in the UK. The intention to live together permanently in the UK requirement is worth a closer look here. Firstly, for out-of-country applications, you would generally not be required to provide supporting documents to prove your intention to live together permanently in the UK. Assuming that there's nothing in the application to suggest otherwise, this intention is usually implied by the very act of submitting the spouse visa application. For in-country applications, the online application form will ask you to provide 6 items of correspondence, as briefly mentioned earlier. While these are not strictly necessary for first-time partner visa applications, these certainly will be expected for partner visa extensions. For partner visa extensions, simply providing the 6 items normally satisfies the requirement of intending to live together permanently in the UK, unless other aspects of the application, such as a significant amount of time spent overseas, brings this requirement into doubt. It should be noted that the intention to live together in the UK requirement applies to every application, right up to the indefinite leave to remain application. So, if either partner plans to spend a significant amount of time abroad before then, you may need to plan this carefully to still meet the requirement. The standard path to indefinite leave to remain, as of the date of this video's release, through the partner visa route involves 3 steps. 1. The first partner visa application. If the first application is made from outside the UK, the applicant will be granted a 33-month visa in the UK. If it's made from inside the UK, the applicant will be granted 30 months leave in the UK via submitting the FLRM application form. 2. The first partner visa extension using the FLRM application form, which will grant another 30 months of leave. And then 3. The ILR application, which is made via the SET-M application form. So, if the applicant and/or sponsor has spent a significant amount of time outside the UK after the first partner visa was granted, but before applying for ILR, this could raise questions about their intent to live together in the UK permanently. The immigration rules doesn't set a strict limit on the amount of time spent outside the UK, because the reason for being abroad matters. If the time overseas is due to study or work, it's usually accepted and should not detrimentally affect the application. The next requirement to discuss is that you and your partner must not fall within the prohibited degrees of relationships. In simple terms, the applicant and sponsor can't be immediate family. Here's a list of the prohibited degrees of relationships. If this requirement concerns you, pause the video and take a moment to review the list. Requirement number 8. Any previous relationships of the sponsor and/or applicant must have broken down permanently, unless one of the rarely relied on exceptions applies. The Home Office focuses mainly on past legally recognised relationships, namely marriages or civil partnerships. If there were any, you must show that they've permanently ended. For marriages, a decree absolute or a final order, or its overseas equivalent, is required by the immigration rules. A decree nisi won't do. Other valid documents depending on the circumstances include a death certificate, annulment, or final civil partnership dissolution order, again, or their overseas equivalents. Like other mandatory documents, this will need to be translated, if not in English or Welsh. Next, we'll cover the UK spouse visa English language requirement and the various ways to meet it. 1. If the applicant is 65 or older at the time of the application, they are exempt from the English language requirement. 2. If the applicant is a national of a majority English-speaking country, they automatically meet the English language requirement. Here are the majority English-speaking nationalities. The only document needed is the applicant's passport confirming that nationality. 3. If the applicant holds a UK-awarded academic bachelor's, master's or PhD, the English language requirement is met by providing the degree certificate. The certificate must show the applicant's name, the title, the date of the award, and the name of the awarding institution. 4. Overseas awarded academic qualifications. If the applicant has an overseas awarded academic bachelor's, master's, or PhD taught in English, it can meet the English language requirement if certain conditions are met. To rely on such a qualification, the qualification certificate must be accompanied by documentation from ECTIS, which is previously known as UK NARIC. These documents don't expire, so if you previously used it in a previous application, it can be reused. If the qualification was not awarded in one of the listed countries, you'll need 2 documents from ECTIS. 1. Proof the qualification meets or exceeds the UK standard for a bachelor's, master's or PhD. And 2. Confirmation the degree was taught or researched in English at or above the required level. If the qualification was awarded in one of the listed countries, you only need to provide ECTIS confirmation that it meets or exceeds the UK standards for a bachelor's, master's or PhD. If none of the earlier options apply, the applicant must usually take and pass a secure English language test, known as a CELT. First, it's important to note that not all English language tests qualify. Only a secure English language test, or CELT, will be accepted. This is a test that is specifically approved by the Home Office and is taken at a Home Office approved test centre. This is worth emphasising, as if another English language test is relied on, this can result in a refusal. Here is the list of the current secure English language tests. The IELTS Life Skills test is a popular choice. It's always held at Home Office approved test centres, and there's plenty of guidance available online and in bookstores worldwide. Unless you have a specific reason, we generally advise against taking the IELTS for UKVI Academic or IELTS for UKVI General Training tests. Here's why. First, many applicants mistakenly book the wrong version, tests with similar names that are not secure English language tests. This is one of the most common reasons for refusal under the English language requirement. To show how easily this happens, here is a valid IELTS General Training Test certificate taken at a Home Office approved test centre. It has a UKVI number and it can be used. In contrast, here's an IELTS academic test certificate taken at a non-approved centre. It looks almost the same, but lacks a UKVI number, so it does not meet the requirement. Secondly, the immigration rules only require a test of speaking and listening. Some tests like IELTS for UKVI Academic or General Training also assess reading and writing, adding unnecessary complexity for some applicants. This list shows English levels from A1 being the lowest to C2 being the highest. For the first spouse visa, the applicant must meet at least A1 level, even if they're applying from inside the UK. For a spouse visa extension after 30 months in the UK, the minimum required level rises to A2. Secure English language tests are valid for 2 years, but if the test was accepted in a previous application, the Home Office will usually accept it even after expiry, as long as it meets the required level for the application being made. So if the applicant's English is strong enough, they can take an A2 or B1 test for the first spouse visa and reuse it later. For example, passing an A2 test for the first spouse visa usually allows it to be relied on for the initial UK spouse visa application and the spouse visa extension. If the applicant passes a B1 level test, they can normally rely on this test for their first UK spouse visa application, their spouse visa extension application, the indefinite leave to remain application, and the British naturalisation application, if the applicant chooses to apply for that. 2 final points on secure English language tests. First, always book through the official test provider's website. Many third-party sites mimic the official pages but are only agents. We provide links to the official websites at migrate.org.uk. Second, you can use YouTube to get an idea whether the applicant's speaking and listening skills meet the A1, A2 or B1 standard. Now let's look at the two situations where the applicant is exempt from the spouse visa English language requirement. First, the applicant is exempt if they qualify for a disability exemption. This applies when a Home Office caseworker agrees that a physical or mental condition prevents the applicant from learning English or taking the required test. Each case is assessed individually. But if the applicant provides medical evidence from a qualified practitioner showing that they're deaf, unable to speak, or have a speech condition that limits communication in English, the exemption is likely to be approved. Secondly, an exemption applies if there are exceptional circumstances that prevent the applicant from meeting the English language requirement. This often comes up when there's no Home Office approved test centres in the applicant's country. However, the guidance makes clear that applicants are usually expected to travel to another country to take the test if needed. Now let's go over the tuberculosis requirement, often referred to as the TB requirement. Some partner visa applicants applying from outside the UK must provide a TB test certificate showing that they're free from active pulmonary tuberculosis. Partner visa applicants applying from inside the UK do not need to provide a TB test certificate. So if you're applying from inside the UK, you can skip to the next part of the video. Let's look at which applicants must submit a TB test when applying from outside the UK. The gov.uk webpage states that a TB test is required if you've lived in any of these listed countries for 6 months or more, and you are living there or another listed country within the last 6 months. The immigration rules, however, suggest a stricter standard. It states which include a period of any length within the 6 months before the date of application, instead of you are living in a TB country within the last 6 months. We won't go into detail here as this will potentially only affect a minority of cases, but in practice, Home Office caseworkers usually follow the less strict approach set out on gov.uk. If the applicant has never spent 6 months in a listed TB country, or has not been in any of the TB listed countries during the 6 months before applying, even if previously present, then no TB test is required. You can skip this section using the video timestamps in the YouTube video. And likewise, if the applicant is a diplomat accredited to the UK, they are exempt from the TB test. So what is the list of TB countries? This list can be found by googling tbtest.gov.uk and then clicking check if you need a TB test for your visa application link here. Ensure you are on the countries where you need a TB test for your UK visa application tab here, and then you will find the up-to-date list here. I say up to date because whilst the list does not change too frequently, it does change over time. So you can check this page when you begin your application and again just before you submit it. Here is the TB country list at the time of shooting this video. It's important to stress that only TB tests taken at Home Office approved clinics will be accepted. Here, looking at the same gov.uk page we mentioned earlier, if you click on a relevant country and then click on this document here, you will see the list of Home Office approved clinics along with more information about booking the test. TB certificates from Home Office approved clinics typically look like this. Some may say Home Office instead of UK Visas and Immigration, and others may be handwritten rather than electronically completed. What matters is that the certificate clearly states that there's no evidence of active pulmonary TB. The certificate normally states you must carry this certificate with you in your hand luggage when you travel to the UK and present it to the immigration officer on arrival. Failure to do so will result in a delay to your journey and you may be required to undergo the tests again. The applicant should bring the TB certificate when entering the UK if it was required in the first place, but immigration officers rarely ask to see it. TB test certificates are valid for 6 months. However, the test only needs to be valid on the date that the Home Office fee is paid on the online application form. It's fine if the certificate expires before the visa centre appointment or the applicant's arrival in the UK. Finally, while sponsors are never required to take TB tests, the requirement can apply to applying dependent children included in the application. Now let's move on to the adequate accommodation requirement for UK spouse visas. This means that you must show that there will be suitable accommodation without using public funds for the applicant, sponsor and any dependent children. A common question is regarding when you need to show that there will be adequate accommodation. For out-of-country applications, the documents must show that there's adequate accommodation for when the applicant arrives in the UK. For in-country applications, the documents must show adequate accommodation at the time the application is decided. The accommodation must be owned or occupied exclusively by the family. This doesn't mean owning the whole property. It means having at least one part reserved solely for the family to sleep in. So, it's perfectly acceptable to rent or rely on a friend or family member's home to meet this requirement. In fact, this is common because it avoids financial commitments, usually costs little to nothing, and friends or relatives are often happy to help with the needed documents. And it's also useful for those who struggle to provide documents for their current housing, for example, if they live in a mobile home. However, having a space reserved for the family to sleep in is not enough on its own. The accommodation must also not be overcrowded. To assess overcrowding, start by counting the number of rooms that can be used for sleeping, not just the bedrooms. Kitchens and bathrooms don't count, but reception or living rooms do. Next, you must assess how many people can live in the accommodation without it being classed as overcrowded. For example, if there are 2 sleeping rooms and 4 people that will live there once the spouse visa is granted, the starting point is that it may be overcrowded. But the guidance makes it clear that not everyone is counted equally. Children under 1 are not counted. Children aged between 1 and 10 are counted as half a person, and the guidance also considers age, gender, and whether people are a couple sharing a room. The Home Office guidance also states that the accommodation must not breach public health regulations. This is rarely an issue, unless the caseworker has clear reason to think otherwise. In fact, we've not once seen this to be an issue, and we've helped more than 5,000 partners with their partner visa applications. The final point of the adequate accommodation requirements is this: the accommodation cannot be prospective. This means that you must show, at the time of the application, that suitable accommodation is already arranged. You can't simply state, "we will find accommodation after the visa is granted." Let's now discuss the financial requirement. The financial requirement is the most common reason for refusals, so it's essential to understand it thoroughly. Let's start with some key financial requirement principles that are often not obvious at first. First, unlike the genuine relationship requirement, the financial requirement is objectively assessed. It's a box-ticking exercise, not just to prove enough income or savings, but also to meet each document-specific rule exactly. Since the financial requirement is assessed objectively, an application that evidences income of £1 million is treated no different to an application which evidences income of £1 above the required amount. On the other hand, an application that evidences income of £1 below the required amount will not satisfy the financial requirement. As with other requirements, if the financial requirement is not met, the default position is that the application will be refused. However, for in-country applications, the application may instead be granted on the 10-year route to indefinite leave to remain, instead of the 5-year route, if there's something in the evidence to suggest it would be unreasonable for a child to leave, or there are insurmountable obstacles to family life with a partner outside the UK, or there are exceptional circumstances. For out-of-country applications, if there are exceptional circumstances, the visa may be granted on the 10-year route instead of the standard 5-year route. The threshold for exceptional circumstances, however, is set very high. It is not enough to show that the situation is difficult or that the rules are almost met. The applicant must show that refusing the visa would breach their rights under Article 8 of the European Convention of Human Rights, the right to private and family life. This area of law can be complex. If you're thinking on relying on exceptional circumstances, legal advice is strongly recommended. This means that, especially for out-of-country applications, if the financial requirement is not met, a visa will almost never be granted. Another key principle worth noting is that, if one source of income is enough to meet the financial requirement, there's no need to include other sources of income, assuming the application is evidenced accordingly. Adding extra sources of income can make the process more complex and increase the number of documents required. For example, the sponsor earns £50,000 a year from employment and £150,000 from self-employment. They would usually be better off submitting only the employment income, as relying on self-employment is something which is normally best avoided if possible. Also, combining employment with self-employment changes the standard way in which employment income is assessed, which adds further complication, as we'll explain later in the video. When it comes to the financial requirement, keeping things as simple as possible is typically best. The date the Home Office fee is paid is called the date of application, and it is this date that the requirements must be met. What happens after that date does not affect the application. So if you're relying on employment income, it doesn't matter if the job ends shortly after applying. Likewise, if you're relying on cash savings, the amount can drop below the required level after the application date without it affecting the decision-making of the application. The good news is that you don't need to calculate the exact income down to a penny. The Home Office won't penalise you for using a different method as long as the income clearly meets the threshold under their rules. That said, please don't become too complacent about this, as the correct calculation of income or cash savings is often not always intuitive, as we'll explain shortly. We will now cover 4 key parts of the financial requirement. First, the required level of income or cash savings to meet the threshold. Second, the requirements for each type of permitted income or cash savings. Third, how to calculate income or cash savings correctly under the immigration rules. And fourth, we will discuss the financial documents you must provide. So, what is the required income or cash savings level to meet the threshold? The first question is whether the sponsor receives any of these, even if they're on behalf of a child. If so, the adequate maintenance test applies instead of the usual financial threshold, meaning you'll need to show significantly less income. Because the adequate maintenance test is much less commonly relied on and changes many of the requirements, the rest of this video will assume that it does not apply. We do, however, explain the adequate maintenance test in detail at migrate.org.uk. If the sponsor doesn't receive one of these, the next question is whether a first-time partner visa application or an extension application is being made. By first-time partner visa applications, we mean out-of-country partner visa applications and in-country applications where the applicant is in the UK on a non-partner visa, such as a skilled worker visa or a youth mobility scheme visa. For first-time partner visa applications, the required income is based on the minimum threshold in force at the time of application. At the time of the release of this video, the minimum income threshold is £29,000 gross. This figure stays the same regardless of whether dependent children are included in the application or not. As you will likely be aware, there is speculation of this changing. If there are any changes, we'll update our website at migrate.org.uk and upload a new YouTube video as soon as possible. It may be worth noting that in previous changes to the required income threshold, applicants who submitted their first partner visa application before the increase were grandfathered into the earlier threshold for all subsequent applications, up to their indefinite leave to remain application. Therefore, some partners may prefer to submit their application by paying the Home Office fee before any upcoming changes take effect, as the date of submission has historically determined whether an applicant is covered under the previous threshold. What about partner visa extensions or indefinite leave to remain applications? Here, we will first refer to applicants who submitted their first application as a fiancé, proposed civil partner, or a married, civil, or unmarried partner before 11th of April 2024 and are applying with the same sponsor and were granted permission on the 5-year route to settlement or indefinite leave to remain. For these extensions or ILR applications, the minimum income threshold is £18,600 gross. Unlike first-time applications under the new rules, this £18,600 figure increases if dependent children are applying, as shown in this table. You'll notice that the minimum income threshold caps at 4 dependent children. It doesn't increase beyond that. So what about partner visa extensions and ILR applications for those who first applied on or after 11th of April 2024? The Home Office guidance currently states, as of the shooting of this video, that the £29,000 minimum income threshold will apply. It's also important to note that, whilst we've referred to the minimum income threshold, cash savings can also be used to meet it, either on its own or combined with other permitted income sources. We'll explain how this works later in the video. And for those wondering, cash savings can also be completely disregarded if the minimum income threshold is met via income. Now, let's go over the different sources of permitted income and how to calculate them. We will refer to categories A to G, which group income types under the immigration rules. Whilst the online application form does not mention categories, it is crucial to know which one applies to you, because each category has different rules, calculations, and documentation requirements. It's also worth noting at this point that no matter which category applies, income or cash savings does not need to be in British pounds. This is because income or cash savings in a foreign currency will be converted to pound sterling using the spot exchange rate which appears on owanda.com for the date of application. This is the case unless 1, you're relying on Iranian rials, which will be converted into pound sterling using the monthly FCDO consular exchange rate applicable on the date of application, or 2, you're relying on a currency that does not appear on owanda.com. This will be converted using the monthly FCDO consular exchange rate on the date of application. Category A, non-specified limited company employment income. If you're unsure what non-specified limited company means, don't worry, we'll explain that in just a moment. Category A is split into 2 categories. 1, where the employed partner is residing in the UK when the application is submitted, and 2, where the sponsor is residing outside the UK when the application is submitted and is returning to the UK once the application is successful. Note that the focus is on where the sponsor is based at the time of application. It does not matter whether the employer is based in the UK or overseas. The rules and calculation are slightly different if the sponsor is living overseas when the application is submitted. In that case, the sponsor must also provide a job offer in the UK that meets the minimum income threshold, either on its own or when combined with other permitted income sources. This video will focus on the calculation and requirements for cases where the employed partner is living in the UK when the application is submitted, as this is by far the most common type of employment income relied on. On that point, if the employed partner is a UK seafarer who qualifies for the HMRC Seafarers Earnings Deduction and spends most of their time at sea, they're generally treated as UK residents for the purpose of the financial requirement. Let's go over the Category A requirements. The first and most basic rule is that the person must be employed. If the person is self-employed, Category A will not be relevant. An exception exists for self-employed subcontractors under the construction industry scheme, as they can include their income under Category A if they meet the specific documentation rules. The second requirement is that the employer cannot be a specified limited company, as such income will be included under a different category. If the employer is a specified limited company, the calculation is different, the requirements are different, and the required documentation is different. A specified limited company is not the same as any limited company. All specified limited companies are limited companies, but most limited companies do not meet the definition of a specified limited company. A specified limited company is something that is defined in the immigration rules as a limited company that is registered in the UK, and the person whose income you are relying on is an employee and or director of that company, and the applicant, sponsor, or family members of the applicant or sponsor hold shares in the employing company, and any remaining shares, not including the applicant, sponsor, or family members of the applicant or sponsor, must be held either directly or indirectly by fewer than 5 other persons. Please note all of these are ands because each condition must be met for the employer to be classed as a specified limited company. For example, if the company is registered overseas, it will not technically be a specified limited company. If the applicant, sponsor, or family members of the applicant or sponsor do not hold shares of the employing company, that company cannot be a specified limited company. If shares are held, but there are more than 4 other persons that hold the remaining shares, it will not be a specified limited company. If the employing company is a specified limited company, we'll cover this later in the video when we discuss Category F. If you're still unsure whether the company is a specified limited company, we have a dedicated article on this on our website, www.migrate.org.uk. The third requirement is that the person must have been employed by the same employer for at least 6 months at the time the application is submitted. If they've been employed for less than 6 months, you should look to Category B. If the only change has been in job title with the same employer, this does not affect eligibility under Category A. What matters is the length of continuous employment, not how long the person has held a specific role within the company. It's also important to correctly identify the employer. In most cases, it's straightforward. But if the person works through an agency, even for different companies, it is usually the agency that is the legal employer. This depends on the facts, and the employment contracts will often clarify the position. Identifying the correct employer is also crucial because under Category A, only income from current employers can be included, not income from previous employers. Fourthly, applicants can include their employment income only if they're in the UK and are working legally. This means that for out-of-country applications, the applicant's employment income cannot be counted, even if they earn a high salary abroad or have a job offer. For in-country applications, most applicants can include their income, except those on visas that don't allow work, such as the fiancé visa. Sponsors, however, can always include their employment income, regardless of whether the application is made from inside or outside the UK. Finally, it's worth noting that changes in pay do not affect eligibility under Category A. This often confuses some partners because if you select not the same amount continuously in the online application form, the system assumes you're applying under Category B, which typically looks at income over 12 months. But under Category A, the relevant period is only the 6 months before the application date, regardless of pay changes during that time. So how is employment income calculated under Category A? First, you need to determine whether employment is salaried or non-salaried, because the calculation method is completely different for each. Salaried employment typically means the employee earns a fixed basic annual amount, such as £40,000, usually set out in the contract. Additional pay, such as overtime, bonuses, or commissions, may be added on top. Non-salaried employment means the employee is paid based on time worked, for example, £25 an hour or £250 a day, and may also earn bonuses, commission, or overtime. The line between the two isn't always obvious, but payslips are often the clearest way to confirm. Here is an example of a salaried payslip. It shows a basic monthly pay of £3,213.46 and a bonus of £1,466. The basic salary, £3,213.46 in this case, tends to stay the same month after month, unless there's a raise or cut. The bonus, however, is more likely to vary month to month. Now, here's an example of a non-salaried payslip. You'll see the term hourly pay, and across the previous 6 months, this hourly figure changes. This variation in pay from month to month is a clear sign that the employment is non-salaried. To calculate salaried employment income under Category A, follow these 3 steps. 1. Gather the payslips from the 6 months leading up to the application date. 2. Identify the lowest total gross pay from those 6 months. This includes basic pay, bonuses, overtime, commission-based pay, travel time payments, and skills or location-based allowances. And ignore deductions like PAYE or national insurance, and ignore net pay. For example, if the lowest monthly gross pay based on these payslips is £4,679.46, that is the figure to use. 3. Multiply that lowest figure by 12 if the payslips are monthly, or by 52 if the payslips are weekly. In this case, £4,679.46 multiplied by 12 is £56,153.52. That final amount is the income figure the Home Office caseworker will assess under Category A, if all the supporting evidence is correct. If the income figure you reached earlier meets or exceeds the minimum income threshold, then you're good to go. But if it falls short, you can try using the longer calculation, which, in a small percentage of applications, may push the total above the threshold. This reflects our earlier point. You don't need to calculate the exact income, you just need to ensure that it clearly meets the threshold in accordance with the Home Office guidance. Here's how the longer salaried income calculation works under Category A. Step 1. Take the lowest total basic gross pay from the 6 months of payslips before applying, and then multiply that figure by 12 for monthly payslips or by 52 for weekly payslips. Referring back to this payslip, the relevant figure for this calculation would be £3,213.46, not the £4,679.46 total gross pay. The figure you calculate here will represent the gross annual basic salary that can be included in meeting the financial requirement. Step 2. Add up the total of the following from the payslips: overtime, bonuses, commission-based pay, payments to cover travel time, and skills or UK location-based allowances. Step 3. Take the total from Step 2, divide it by 6, and then multiply that by 12. And then Step 4. Add the Step 1 and Step 3 results together. This final figure is what the Home Office caseworker will use to assess whether the financial requirement is met. Again, most partners won't need this more complex calculation. It's only useful in rare cases, where the initial method falls short, but the longer method helps meet the financial requirement. To calculate non-salaried employment income under Category A, follow these steps. Step 1. Gather all payslips from the 6 months before submitting the application, and then add up the total gross income received during that period. You can include basic hourly or daily pay, such as £20 an hour, overtime, bonuses, commission-based pay, payments to cover travel time, and skills and UK location-based allowances. For example, this table displays the total monthly gross pay from the monthly payslips covering the 6 months before submitting the application. These 6 figures add up to a total of £17,000. Step 2. Take the total gross income from Step 1 and then divide it by 6. And this applies regardless of whether the payslips are weekly or monthly. £17,000 divided by 6 is £2,833.33. And then finally, Step 3 will require you to multiply this figure by 12. £2,833.33 multiplied by 12 equals £33,999.96. This figure is the amount that can be included as non-salaried employment income under Category A. If the person has received maternity, paternity, adoption, or sick pay during the 6 months before applying, the rules offer extra flexibility in calculating income. In this case, you can choose to base the income calculation on the standard 6 months before submitting the application, or the 6 months before the maternity, paternity, adoption, or sick pay. This can help ensure that certain temporary reductions in income do not prevent the application from meeting the financial requirement. And we cover this in more detail on our website, migrate.org.uk. Category A employment income can be combined with other sources of income to meet the financial requirement. It can be combined with other Category A employment income. For example, if the person has 2 jobs and has been with both employers for 6 months or more, both incomes can be included. And for in-country applications, if both the sponsor and applicant have been employed for 6+ months, their incomes can be counted together under Category A. Category A income can also be combined with Category C non-employment income, Category D cash savings, and Category E pension income. We'll cover these additional sources of income later in the video. Category A employment income can also be combined with specified limited company income and self-employment income as a sole trader under Category F. However, doing this will change the way that the employment income is calculated, and it will affect the relevant time period used. We'll explain this in more detail later in this video when we cover the Category F incomes. Category A employment income cannot be combined with Category B employment income. If one of the jobs must be included under Category B, for example, because the person has been employed for less than 6 months, then both incomes must be assessed under Category B. Under Category A, there are both mandatory and optional documents, both of which are set out in paragraph 2 of Appendix FMSE. It is mandatory to provide employment payslips covering the 6 months immediately prior to the date of application, which is the date the online application is submitted. If the payslips are not formal, they must be accompanied by a letter from the employer on the employer's headed paper and signed by a senior official, confirming that the payslips are authentic. It's also mandatory to provide personal bank statements covering the 6 months before the date of application and a letter from the employer. This letter must be from the employer or employers who issued the payslips and must confirm 1. The person's employment and gross annual salary, 2. The length of their employment, 3. The period over which they have been or were paid the level of salary relied upon in the application, and 4. The type of employment, whether that's permanent, fixed-term contract or agency. Because of this, we are particularly specific about the letters that we provide to our clients for them to send to their employer or employers. And if the employee is a director of the UK limited company which provides them with employment income, it is mandatory to provide evidence that the company is not a specified limited company. We have a section specifically regarding specified limited companies in this video where we discuss Category F. There is also technically optional documentation, because if it's not submitted in the first place, Home Office caseworkers may request it when they're reviewing the supporting documents. This is different to mandatory documents where, if not provided in the first place, can result in a refused application outright. Employment contracts and a P60 covering the 6 months prior to the application being submitted are optional. Let's now move on to non-specified limited company employment income under Category B. Like Category A, Category B is split into 2 categories. 1, where the employed partner is residing in the UK when the application is submitted, and 2, where the sponsor is residing outside the UK when the application is submitted and is returning to the UK once the application is successful. This video will focus on the calculation, requirements, and documents for applications where the employed partner is living in the UK, as this is the most common scenario when relying on employment income under Category B. In short, Category B applies to employees who have been employed with their current employer for fewer than 6 months at the time of application, or have been employed with their current employer for more than 6 months, but who don't meet the financial requirement under Category A. If you've already met the requirement under Category A, feel free to skip this section. There's no need to spend time on rules that don't apply to you when there are other requirements that you should prepare for. For the most part, the Category B requirements are similar to those under Category A. 1, the person must be employed at the time of the application. 2, the employer must not be a specified limited company. And 3, the applicant can include their income only if they're in the UK and are working legally. This means that applicants outside the UK cannot count their income towards the financial requirement. The key difference from Category A is that there's no minimum length of employment under Category B. As we'll explain shortly, particularly high-earning applicants or sponsors can sometimes meet the financial requirement after just 1 week or 1 month of employment. Under Category B, there are 2 tests that must both be satisfied. If you only meet one, the financial requirement will not be met. Test 1. The current gross annual income from employment must equal or exceed the minimum income threshold we discussed earlier. I say current because this test focuses only on the job or jobs held at the time of the application. Previous jobs don't count for this part. The way you calculate current gross annual income under category B depends on whether the job is salaried or non-salaried. For salaried employment, take the most recent payslip, which is dated within 28 days before the application is submitted, and then multiply it by 12 if paid monthly, or by 52 if paid weekly. That's the figure used for Test 1 under category B for salaried employment. For non-salaried employment, follow these 3 steps. Step 1. Add up the total gross employment income received since the job started, up to a maximum period of 12 months. Step 2. Divide this by the number of months if monthly payslips are issued, weeks if weekly payslips are issued, or by days if daily payslips are issued, again up to the 12 months max from the employment start date. Step 3. Multiply this figure by 12 if monthly payslips are issued, 52 if weekly payslips are issued, or by 365 if daily payslips are issued. The result will be the figure for non-salaried employment income that can be included towards the financial requirement in Test 1. The figure in Test 1 can be combined with other Category B employment income, non-employment Category C income, such as property rental income, cash savings under Category D, and pension income under Category E. Test 2 requires the person to have received income at or above the required level in the 12 months before applying. This test looks at what was paid, not what is currently being earned, so it covers all employment income received from non-specified limited companies in the 12 months before applying. To work out Test 2, gather the payslips for up to the 12 months before submitting the application, and then add the total gross pay in that period. Category B lets you count base salary, travel time pay, overtime, commission, skills and UK location allowances, and bonuses. For this payslip, use the £4,679.46 gross figure. Ignore deductions. Net pay does not matter here. You may also count income from previous non-specified limited company jobs in the same 12-month window. Up to 12 months means that there's no need for continuous work, so gaps in employment are fine. Furthermore, unlike Category A, which needs 6 months employment, Category B has no set work length rule. Instead, the employee just needs to be employed at the time the application is submitted. This means that high earners can qualify with less than 6 months on the job. For example, a sponsor worked only 2 months in the last 12. Their salary is £240,000 a year. Their second and most recent payslip shows £20,000 gross pay. That payslip clears Part 1. Their current annual pay of £240,000 exceeds the minimum threshold. And their 2 payslips satisfy Part 2, as they have earned above the threshold during their 2 months of employment. This figure in Test 2 of the 2-part Category B test can be combined with other Category B employment income, non-employment Category C income, such as property rental income, and the total gross amount of pension income received in the same 12-month period under Category E. Importantly, cash savings cannot be combined with Test 2 of the 2-part Category B test. It can only be combined with Test 1. So if you don't meet the financial requirement by combining employment income under Category B with cash savings under Category D, partners often resolve this by waiting until the employed partner has worked for 6 months. Then they can combine their employment income under Category A with cash savings under Category D, as there is no restrictions on combining cash savings there. Like Category A, Category B has both mandatory and optional documentation. It is mandatory to provide payslips covering any period of employment in the 12 months prior to the date of application, and if the payslips are not formal, then it's also required to accompany the payslips with a letter from the employer on the employer's headed paper and signed by a senior official, confirming the payslips are authentic. It's also mandatory to provide bank statements which cover the same periods as the payslips relied on, as well as a letter from the employer who issued the payslips, which confirms 1. The person's employment and gross annual salary, 2. The length of their employment, 3. The period over which they have been or were paid the level of salary relied on in the application, and 4. The type of employment, whether that's permanent, fixed-term contract, or agency. If the person is a director of the employing company, it's mandatory to provide evidence that the employing company is not a specified limited company, which we discuss later in this video when we discuss Category F. Optionally, partners can provide their most recent P60 document and a signed employment contract. Now let's cover specified limited company income. The first requirement is that the company that provides the income must qualify as a specified limited company. We discussed the specified limited company definition earlier on in this video when we discussed employment income. In short, specified limited company is one where all of the following conditions are met. The company is a limited company registered in the UK, and the person whose income you are relying on is an employee and/or director of that company, and the applicant, sponsor, or family members of the applicant or sponsor hold shares in the employing company, and the remaining shares, not including the applicant, sponsor, or family members of the applicant or sponsor, must be held either directly or indirectly by fewer than 5 other persons. The second requirement is that the specified limited company must have finished at least one full financial year, as you'll need to submit accounts and business bank statements specifically from that year. If the specified limited company has not finished a full financial year, there are usually 2 options. 1, use another source of income to meet the financial requirement, or 2, wait until a full 12-month financial year has passed and then submit the application, provided that the financial requirement is met. The third requirement is that the company's most recent full financial year should be 12 months long. Most UK companies follow this, but first trading years can be shorter or longer. That may cause issues because the Home Office guidance specifically refers to the company's financial year as a 12-month period. If the specified limited company's most recent full financial year is not 12 months, this could cause issues, depending on the Home Office caseworker handling your case. Next, there must be ongoing employment or dividend income after the company's full financial year. If you can't show continued income, for example, if the company closed, you can't count that income. The fifth requirement is that if the company is not required to file audited accounts, as is common, you will need an accountant. You will also need to provide an accountant certificate of confirmation, which we will discuss shortly. Now, to calculating specified limited company income. It's usually counted under Category F. Category G is possible, but involves far more paperwork. In almost all cases, partners can ignore it. Start by finding the company's most recent full financial year on the CT 600 company tax return. In this example, the year runs from 1st of November to 31st of October. If you apply on or before 30th of October 2026, just before the year end, the relevant financial year will begin on the 1st of November 2024 and end on the 31st of October 2025. If you apply on the 1st of November 2026, just after the year ends, the relevant financial year will begin on the 1st of November 2025 and end on the 31st of October 2026. Often, this means filing the New Year's accounts earlier than UK tax deadlines require. Step 2. Add up all of the gross employment income earned in the financial year you identified in Step 1, and if dividends were declared during or in respect of that financial year, include them too. The words "or in respect of" means that dividends are not required to have been paid during that year. They can be received after it ends, as long as it's before the application is filed. The combined total of the employment and dividend income, as mentioned earlier, is the amount that you can include towards the financial requirement under Category F, assuming that all of the required documentation is correctly submitted. Small business owners often take money out as needed and let the accountant handle records and tax efficiency. Accountants may label payments creatively, like director's loan repayments instead of salary or dividends. But for the application, clearly show the employment and dividend income you're counting, as it's only those 2 types that qualify. If you meet the requirement under Category F, skip Category G. It's far heavier on the paperwork. Specified limited company income can be combined with other sources of income. It can be combined with employment income from a non-specified limited company, other non-employment income under Category C, such as property rental income, and pension income under Category E. However, when specified limited company income is combined with other sources of income, the other incomes period normally shifts to match the company's financial year. For example, the date of application was 1st of January 2026, and the relevant financial year of the specified limited company, as stated in the CT 600 company tax return document, was 1st of November 2024 to 31st of October 2025. Any income from November 2025 to December 2025 does not count. It's outside the relevant financial year. If we total the income from the specified limited company between the 1st of November 2024 and 31st of October 2025, the relevant financial year, this will mean that £18,000 specified limited company income can be included towards the financial requirement. Normally, non-specified company employment income under Category A looks at the 6 months before application. However, when you combine specified limited company income with non-specified limited company employment income, in this example, it will only be November 2024 to October 2025 which are relevant when determining the amount of non-specified limited company income that can be included towards the financial requirement. And this is because when you combine specified limited company income with other sources of income, the general rule is that the relevant period changes to match the specified limited company's relevant period. Specified limited company income under Category F cannot be combined with cash savings, self-employment income, and sources of income that are not sources of income when the application is submitted. Continuing with the example of combining specified limited company income with non-specified limited company income, here you can see that the non-specified limited company income stopped becoming a source of income 2 months before submitting the online application. Therefore, in this instance, since the non-specified limited company employment income is no longer being received at the time of submitting the online application, it cannot be included towards meeting the financial requirement. The required documentation to evidence specified limited company income is rather extensive. You will need to obtain personal bank statements covering the specified limited company's last full financial year. We discussed identifying this financial year earlier when we discussed the calculation of income. As previously mentioned, Category G requires documentation relating to the last 2 full financial years, but is rarely relied on, so we will just focus on Category F. If you're relying on employment income, employment payslips covering the company's last full financial year is required. These payslips must be either 1. Formal payslips issued by the employer and showing the employer's name, or 2. Accompanied by a letter from the employer on the employer's headed paper and signed by a senior official, confirming the payslips are authentic. If issued, a P60 covering the company's last full financial year should be submitted. If the person received any dividends from the employing company, dividend vouchers declared in favour of the person during or in respect of the company's last full financial year is required. Corporate or business bank statements covering the company's last full financial year is also required. For specified limited company applications where the applicant and sponsor are not directors, this is one of the sometimes uncomfortable documents to request due to their sensitive nature. It's important to stress, however, that such documentation is mandatory and the application will likely be refused if not submitted. You will also need to provide evidence of ongoing employment or receipt of dividend income from the company. To satisfy this, if reasonably practical, you should provide the following documents which cover the period since the end of the employing company's most recent full financial year until you submit the application. Payslips, dividend vouchers, personal bank statements showing receipt of the employment and/or dividend income, and business bank statement showing the employment and/or dividend income leaving the business account. If you're unable to provide these, you can instead submit evidence of ongoing payment of business rates, business-related insurance premiums, or employer national insurance contributions in relation to the company. Such documentation should be dated within 3 months of submitting the online application. You'll also need to provide evidence of registration with the Registrar of Companies at Companies House, a company tax return CT600 document for the most recent full financial year, and evidence that the CT600 company tax return document has been filed with HMRC. If the company is required to produce annual audited accounts, such accounts must cover the last full financial year. If the company is not required to produce annual audited accounts, you must provide 1. Unaudited accounts for the last full financial year, as stated in the most recent CT600 company tax return document, and 2. An accountant certificate of confirmation, which is essentially a document which confirms that the accountants have prepared or approved the unaudited accounts. Please ensure that your accountant is a member of one of these bodies, as this is a mandatory requirement. And then finally, one of the following documents must also be provided. 1. A certificate of VAT registration and the VAT returns for the last full financial year, confirming the VAT registration number if turnover is more than £79,000 or was in excess of the threshold which applied during the last full financial year. Or 2. Proof of ownership or lease of business premises. Or 3. Proof of registration with HMRC as an employer for the purposes of PAYE and national insurance, proof of PAYE reference number, and account office reference number. If the online application form requests a current appointment report, disregard that as this is no longer required. Now let's cover other non-employment income, which falls under Category C. This covers several income types. You can find a list of these income types here. Unlike employment and self-employment income, both the sponsor and applicant can include this income towards the financial requirement for both out-of-country and in-country applications. Let's discuss the requirements for these sources of income. There are two general mandatory requirements. First, the asset that produces the income must belong to the applicant, sponsor, or both. Rental income from a family member's property does not count, for example. Second, the asset must still be owned when you apply. If you've sold it, that income can't be included. It does not, however, need to be owned for 12 months. For example, if you held a property for 4 months and earned rent, that 4-month income still counts. Additional requirements can apply, depending on which one of these you choose to rely on. The general rule for these sources of income, with the exception of maintenance grants and stipends, is that you can include the gross amount received in the 12 months before applying. Each of the Category C sources of income may have additional complexities regarding their calculation, which are further explained in the minimum income requirement document from the Home Office. For example, for property rental income, the amount typically includable is the gross rental income received during the 12 months prior to submitting the online application, before deducting any management fees. A common misunderstanding is regarding dividends or other income from investments, stocks and shares, bonds or trust funds. For example, an applicant owns £100,000 of Microsoft stock and receives £1,000 in dividends in the 12 months before applying. Only the £1,000 counts under Category C. Selling the stock for £100,000 does not count as income under Category C. Rather, that money is typically included as cash savings under Category D if it meets the cash savings rules. We will discuss including cash savings under Category D shortly. Category C non-employment income can typically be combined with employment income under Category A and B, other non-employment income under Category C, cash savings under Category D, pension income under Category E, specified limited company income under Categories F and G, and self-employment income as a sole trader, partner, or franchise under Categories F and G. Please note, however, as we discussed earlier in the video, when Category C income is combined with Category F, the relevant period of the Category C income changes to the Category F relevant period. The required documents depend on what type of Category C income is relied on. These can be found in paragraph 10 of Appendix FMSE, which can be seen here. Next, we'll look at cash savings for UK spouse and partner visas under Category D. There are 3 different types of cash savings applications. 1. Cash savings that have been held for at least 6 months when the application is submitted. 2. Cash savings that have been held for less than 6 months but are from a property sale within the past 6 months. And 3. Cash savings that have been held for less than 6 months but are from liquidating or moving investments, stocks, shares, bonds or trust funds within the past 6 months. We'll discuss each of these in turn. We'll begin by discussing the general cash savings requirements that apply to all types of cash savings applications. In every case, the cash savings must be held in the applicant's personal bank or savings account, the sponsor's personal bank or savings account, or a joint bank or savings account shared by both the applicant and sponsor. So yes, applicants can include their own cash savings if the requirements are met. It's also worth noting here that the account should not be jointly held by anyone else, like an applicant or sponsor and a parent. Cash savings don't need to be held in British pounds. Cash savings held in a foreign currency is converted using the oanda.com closing spot exchange rate on the application date. This is the case unless 1. You're relying on Iranian rials, which will be converted into pounds sterling using the monthly FCDO consular exchange rate applicable on the date of the application, or 2. You're relying on a currency that does not appear on oanda.com. This will be converted using the monthly FCDO consular exchange rate on the date of application. The cash savings can be held in a bank or savings account that is either a current, deposit, or investment account. But please note that particular care needs to be taken where the funds are held in a brokerage account in which stockbrokers use funds to purchase shares for the account holder, or betting accounts held with a bookmaker or gambling operator, as these are specifically mentioned in the guidance as accounts which do not meet the criteria of being a bank or savings account. The cash savings must be immediately withdrawable, either with or without penalty. This means that the money locked in a fixed deposit account cannot typically count unless moved to a personal bank or savings account where the funds are immediately withdrawable. Such a situation is covered by the provision in the immigration rules that we will discuss shortly. Cash savings must come from a legal source. You must declare where they came from, and the Home Office usually accepts your statement without deep investigation. The account must be with a bank or institution regulated in its country. In the UK, that's the FCA or PRA. You must provide regular bank or savings statements for your cash savings. They should show account holder names, an identifiable account number, and the bank or institution's name. Regular is not defined, but statements should be clear and complete. Please do not redact or blank out certain sections of your statements. Finally, the immigration rules states that savings must be held in cash. On this point, stocks and shares are not cash, bonds are not cash, and equity in a house is not cash. However, there are specific provisions which permit including these if sold or liquidated before applying, and we will cover these specific provisions shortly. However, there are two caveats here. Despite not being catered for in the immigration rules, the Home Office guidance states, in the UK, a stocks and shares individual savings account does meet the definition of a savings account, and the funds can be considered as cash savings if all of the requirements here are met. Whilst it's arguably not compliant with the immigration rules, which states that savings must be in cash, we've relied on unliquidated stocks and shares within UK stocks and shares ISAs countless times without issue. In fact, I will likely rely on this to meet the financial requirement when I submit my partner's application in the very near future. I'm considering making a video documenting that process if I think that viewers will find it helpful. We do not see Home Office caseworkers reliably treat other types of investment accounts as favourably. Therefore, if you rely on unliquidated stocks and shares in an account which is not a UK stocks and shares ISA, there is a substantial chance of the application being refused. How about NS&I premium bonds? We've not seen our clients facing any issues relying on these premium bonds without liquidating them. But we have heard from others that the Home Office caseworker took issue with it, so if you want to rely on the NS&I premium bonds but want to own the side of caution, you may consider liquidating them and then transferring the cash funds into a personal account before applying. To calculate cash savings held for 6 months before applying, follow the following steps. Step 1. Find the lowest total balance during the 6 months before applying. If the savings are in one account, just check the statements for the lowest figure. If spread across accounts, you can use an Excel sheet to track daily balances and spot the lowest combined total. This helps you confirm that you meet the required amount of cash savings and makes it easier for the Home Office caseworker to review. Most banks let you download Excel statements, saving time and avoiding manual entry. If the cash funds are not in British pounds, you should list the relevant conversion figure as we discussed earlier in this video. Step 2. Subtract £16,000 from the lowest balance found in Step 1. And then finally, step 3, divide this number by 2.5, assuming you're applying for a spouse or partner visa and not indefinitely to remain, where this step is not relevant. The result is the cash savings gross annual income equivalent figure you can count towards the financial requirement. Here is a table showing cash savings and their gross annual income equivalents. The required documentation to evidence cash savings is relatively minimal, although strict document-specific requirements do apply. For cash savings applications where the cash savings relied on has been held for 6 months or longer when the application is submitted, it is mandatory to provide personal bank or savings statements showing at least the level of cash savings relied on in the application has been held in an account or accounts in the name of the applicant, sponsor, or the applicant and sponsor jointly throughout the period of at least 6 months prior to the date of the online application submission. In addition to providing bank statements, it is mandatory for the person or persons holding the cash savings to provide a declaration regarding the source or sources of the cash savings. The second type is cash savings held for less than 6 months, but coming from a property sale within the past 6 months. For property sale savings held for less than 6 months, the standard 6-month period adjusts. You shorten the 6-month period by the time before the sale proceeds hit your account. So, for example, if the sale money arrives 2 months before applying, you only need to show 2 months worth of statements, not 6, if you evidence the application accordingly. If the property was co-owned by someone other than the applicant or sponsor, only the share belonging to the applicant, sponsor, or both counts. The third party's portion cannot be included. Cash savings from a property sale require more supporting documents than just bank statements and a savings declaration. You will also be required to provide documents which show 1. The property, or relevant share of the property, was owned by the applicant, sponsor, or applicant and sponsor jointly at the beginning of the period of 6 months before submitting the application and the date of sale. On this point, if the property was owned by the sponsor's or applicant's limited company, This cannot be included as the limited company is considered to be a separate legal entity. 2. The applicant and/or sponsor's shares if ownership of the property was shared with a third party, i.e. someone other than the applicant or sponsor. And 3. The funds deposited as cash savings are the net proceeds of the sale, once any mortgage or loan secured on the property has been repaid, and once any taxes and professional fees associated with the sale have been paid. The Home Office suggests the following documents may be submitted to show this. 1. Registration information or documentation from the Land Registry or overseas equivalent. 2. A letter from a solicitor or other relevant professional if the sale took place overseas, instructed in the sale of the property, confirming the sale price and other relevant information. 3. A letter from the lender, a bank or building society, on its headed stationery regarding the repayment of a mortgage or loan secured on a property. 4. Confirmation of payment of taxes or professional fees associated with the sale. And 5. Any other relevant evidence that shows the requirements are met. The third type covers cash savings held for less than 6 months, but come from selling or moving investments within the past 6 months. So this provision covers, among other things, stocks and shares held in an investment account, investments held in a pension drawdown account, gilts or bonds held in an investment account, and funds held in money market or trust funds. Like property sales, this provision can shorten the 6-month period by the time before the funds became cash. For example, if you held a stock portfolio for over 6 months and received the money in a personal bank or savings account 3 months before applying, you'd only technically need to show 3 months of bank or savings statements. In addition to providing bank or savings statements and a cash savings declaration, as previously discussed, you must provide evidence showing that the investments, stocks, shares, bonds or trust funds were in the ownership and under the control of the applicant, sponsor or both jointly for the part of the 6-month period before the date of application, before they were liquidated into cash savings. The value of the investments, stocks, shares, bonds or trust funds at or before the beginning of that 6-month period was at least equivalent to the amount of the cash savings relied on in the application, and that the general cash savings requirements are met. For a detailed write-up about the cash savings requirements as they apply to UK spouse or partner visas, feel free to check out our website www.migrate.org.uk. Cash savings can be combined with employment income under Category A and Part 1 of the 2-part Category B test, other non-employment income under Category C, and pension income under Category E. Cash savings cannot be combined with specified limited company income under Category F, or self-employment income as a sole trader, partner, or franchise under Category F. Now let's look at pension income under Category E. Both applicant and sponsor can include their pension towards the financial requirement for out-of-country and in-country spouse visa applications. Pension income must start at least 28 days before the application date, and pensions can be state pensions, UK or overseas, and it can also be occupational or private pensions. When calculating the amount of pension income includable, the starting point is that you can include the current gross annual pension income being received when the application is submitted, not the past year's total. For example, a partner began getting £2,000 a month 3 months ago. £2,000 multiplied by 12 is £24,000. That £24,000 is the includable amount, not the £6,000 from the past year. The exceptions to this calculation are 1. Pension income is being combined with Category B income, in which case, when it comes to Part 2 of the Category B test, the relevant amount is the amount received in up to the 12 months before applying, and 2. Category F is relied on. In such a case, the relevant pension income amount is the amount received during the relevant Category F period. Furthermore, as we discussed in the Category F section in this video, the pension income will need to be an ongoing source of income when the application is submitted. Broadly speaking, there are 2 pension types, annuities and drawdowns. Annuities pay a set income for life or for a fixed term. Drawdowns keep funds invested and let you withdraw when needed. For Category E, the Home Office typically focuses on annuities. If you use drawdowns, it's usually better to treat the withdrawn funds as cash savings, using the rule for investments sold within 6 months. We discussed that further in our cash savings section of this video. Pension income can be combined with other sources of income. It can be combined with employment income under Category A and B, other non-employment income under Category C, cash savings under Category D, specified limited company income under Category F, and self-employment income as a sole trader, partner or franchise under Category F. To evidence pension income, you'll first need to provide official documentation from 1. The Department for Work and Pensions or other government department or agency, including the Veterans Agency, 2. An overseas pension authority, or 3. A pension company. This official documentation must confirm the pension entitlement and amount. And if there have recently been any cash withdrawals from the pension, the documentation confirming the pension entitlement and amount must reflect the current pension income that is being received when you submit the online application. The second and final mandatory document is at least one personal bank statement in the 12-month period prior to the date of application, showing payment of the pension into the person's account. Self-employment income is a sole trader, partner, or franchise. Self-employment income here specifically means working as a sole trader, partner, or franchisee. If you own a UK limited company, that income usually counts as specified limited company income, if no more than 4 others hold the remaining shares. We have a specific section in this video that discusses specified limited company income. To use self-employment income, 1 financial year must have passed since starting the business. This matters because you'll need documentation for the latest tax year, which in the UK is 6th of April to 5th of April. Thirdly, self-employment must be ongoing at the time the application is submitted. Fourthly, applicants can only include their self-employment income if they're in the UK and are working legally. For out-of-country applications, applicants cannot include their self-employment income, no matter their level of earnings. Finally, the immigration rules makes a distinction between applicants and sponsors who are self-employed in the UK when the application is submitted, and sponsors who are self-employed overseas who plan to return to the UK. For sponsors self-employed overseas who will be returning to the UK with the applicant to work, will need to provide evidence of either 1. That their self-employment is ongoing and will be continuing in the UK, or 2. A confirmed job offer of salaried or non-salaried employment in the UK starting within 3 months of their return. To calculate self-employment income, first identify the most recent full financial year. For UK self-employment, that's the most recent 6th to 5th of April period that passed. For example, if the application is submitted on the 4th of April 2026, just before the financial year ends, the relevant financial period will be the 6th of April 2024 to the 5th of April 2025. On the other hand, if you apply on the 6th of April 2026, just after the financial year ends, the relevant financial period will be the 6th of April 2025 to the 5th of April 2026. 2 key points are worth making here. First, if self-employed overseas, the financial period follows that country's tax rules. Ask a local accountant. Second, the immigration rules may force you to file a tax return and accounts earlier than what HMRC requires. If you apply soon after the 5th of April, depending on when you want to submit the application, you might need to submit the self-assessment right away. The second step is to identify the gross taxable profits from the person's share of the business in this period, not including any deductible allowances, expenses, or liabilities which may be applied to the gross taxable profits to establish the final tax liability. This is the number you can technically use for Category F if documented correctly. The simplest way is to get this figure from an accountant. Home Office caseworkers aren't accountants and commonly rely on the figure provided. If there is no accountant, one may be needed to meet the immigration rules. We cover this in our Accountants and UK Spouse and Partner Visas video. With this being said, it's worth noting that we've seen Home Office caseworkers deviating from what is stated in the immigration rules and guidance and instead insist on relying on the net taxable profits figure. So, if possible, to err on the side of caution, you should ensure that the net profit figure exceeds the minimum income threshold. Self-employment income can also be included under Category G. Here, you'll have to provide documentation relating to the 2 most recent financial years and calculate the average of those last 2 full financial years. But Category G is rarely used. It's paperwork heavy and is usually only a fallback when Category F does not work, so in 99% of applications, only Category F will be relevant. Self-employment income as a sole trader, partner, or franchise can be combined with non-specified limited company employment income, other non-employment income under Category C, pension income under Category E, and other self-employment income as a sole trader, partner, or franchise if the relevant financial period is the same. However, when you combine self-employment with other income, the other income's period usually shifts to match the self-employment year, 6th of April to 5th of April in the UK. For example, The applicant wants to submit the application in June 2026. The sponsor wants to combine non-specified limited company employment income with their sole trader income. Here, the amount of employment income includable will be the gross amount received during 6th of April 2025 to 5th of April 2026. It will not be the 6 months before applying under Category A or up to the 12 months before applying under Category B, as is standard. Self-employment income as a sole trader under Category F cannot be combined with either cash savings, specified limited company income, or other sources of income which are not a source of income when the application is submitted. The required documentation to evidence self-employment income can be relatively burdensome to obtain. You will need to obtain personal bank statements covering the last full financial year. Again, for UK self-employment, that's the most recent 6th to 5th of April period that passed. And as previously mentioned, Category G requires documentation relating to the last 2 full financial years, but is rarely relied on, so we will just focus on Category F. If the self-employed person has, or used to have, a separate business bank account, business bank statements covering the self-employed person's last full financial year will need to be provided. You will also be required to provide documentation, which is typically best obtained from an accountant. These are 1. Evidence to show the amount of tax payable, paid and unpaid for the last full financial year. 2. An annual self-assessment tax return to HMRC for the last full financial year. 3. A statement of accounts for the last full financial year. 4. If available, proof of registration with HMRC as self-employed. 5. A document that shows the self-employed person's unique tax reference number, the UTR, and or the UTR of the partnership or business. 6. You must submit at least one of the following: a business bank statement that shows transactions relating to ongoing trading that are dated no more than 3 months before you submit the online application. If the person does not have a business bank account, you can submit a personal bank statement instead, or evidence to show the self-employed person has renewed a license to trade. This evidence must be no longer than 3 months old by the time you submit the online application, or evidence to show ongoing payment of business rates or business-related insurance premiums, employer national insurance contributions, or franchise payments to the parent company. And this evidence must also be no longer than 3 months old by the time you submit the online application. 7. You must also submit one of the following. If the business is required to produce annual audited accounts, these accounts must be included for the last full financial year. Otherwise, as is most commonly the case, if the business is not required to produce annual audited accounts, unaudited accounts for the last full financial year should be provided along with an accountant's certificate of confirmation. Whilst unaudited accounts may not be required by HMRC, this is a mandatory requirement for the application. Therefore, if one has not already been created, we would very strongly recommend asking the accountant for this. An accountant's certificate of confirmation is essentially a document from the accountant which confirms that they've prepared and/or approved the accounts provided. You should also note that the accountant must be a member of one of these bodies. Alternatively, you can provide a certificate of VAT registration and the VAT return for the last full financial year, confirming the VAT registration number if that turnover is in excess of £79,000 or was in excess of the threshold which applied during the last full financial year, or evidence to show appropriate planning permission or local planning authority consent is held to operate the type or class of business at the trading address, or a franchise agreement signed by both parties. It should be noted that if the self-employed person's organisation is a franchise, which is only a minority of applications, a franchise agreement signed by both parties must be submitted. We've covered which income sources count towards the financial requirement. Now let's look at income that can't be included. Firstly, as mentioned earlier, for out-of-country applications, the applicant's employment and self-employment income cannot be included towards the financial requirement. Second, as a general rule, income from benefits cannot count towards the financial requirement for UK spouse and partner visas. The exception to this is if the sponsor receives, whether that's on behalf of their child or not, one of the following. As previously mentioned, if the sponsor gets certain benefits, the adequate maintenance test applies instead. We provide a detailed step-by-step guide for the adequate maintenance test on our website, www.migrate.org.uk. Third, loans and credit don't count. So you can't borrow £100,000 and use that as cash savings to meet the financial requirement. Fourth, in nearly all cases, third parties usually cannot sponsor the application if the required income is not met. An exception to this is if a friend or family member gifts you cash savings. But you will need to hold the gifted funds for 6 months before applying. Another exception to the rule against third-party sponsorships applies in cases of exceptional circumstances, where refusal of the application could breach Article 8 due to the risk of unjustifiably harsh consequences for the applicant, sponsor, or a relevant child. With that said, it is almost always the case that the circumstances are not deemed exceptional enough by the Home Office, as the threshold for meeting this requirement is very high. The suitability requirements. In short, the suitability requirements are a separate set of immigration rules that govern whether a Home Office caseworker will or may refuse an application. Recent changes have led to stricter rules for UK partner visa applicants, whether applying out of the UK or in the UK. The application will be refused if 1. There are relevant exclusion, deportation order, or travel ban grounds. 2. The applicant's presence in the UK is not conducive, i.e. beneficial, to the public good because of their conduct, character, associations, or other reasons. 3. There are relevant exclusions from asylum or humanitarian protection grounds. 4. The applicant has been convicted of a criminal offence in the UK or overseas for which they have received a custodial sentence of 12 months or more. 5. The applicant is a persistent offender who shows a particular disregard for the law. 6. The applicant has committed a criminal offence or offences which caused serious harm. 7. The applicant's parent or parent's partner poses a risk to the applicant. 8. The applicant has used deception by making false representations or by providing false documents or information in the application, or by not disclosing relevant facts in relation to the application. And 9. There are medical reasons resulting in it being undesirable to grant entry clearance, unless there are strong compassionate reasons justifying admission. Depending on the Home Office caseworker's discretion, an application may be refused where 1. The applicant has been convicted of a criminal offence in the UK or overseas for which they have received a custodial, i.e. prison sentence of less than 12 months. 2. The applicant has been convicted of a criminal offence in the UK or overseas for which they have received a non-custodial sentence or received an out-of-court disposal that is recorded on their criminal record. 3. Where it is more likely than not that the applicant is or has been involved in a sham marriage or a sham civil partnership. 4. Where the applicant or third party, in relation to the application, has made false representations or provided false documents or false information in relation to the application, whether or not relevant to the application or to the applicant's knowledge. 5. Where the applicant or third party did not disclose relevant facts in relation to the application. 6. Where the applicant, without reasonable excuse, fails to comply with a reasonable requirement to attend an interview, provide information or biometrics, undergo a medical examination, or provide a medical report. 7. The applicant has failed to pay charges under relevant NHS regulations on charges to overseas visitors, and the outstanding charges have a total value of at least £500. 8. The applicant has failed to pay litigation costs awarded to the Home Office. And 9. A medical inspector advises that, for medical reasons, it is undesirable to grant entry to the person. For some, it's also crucial to note that if there have been breaches of UK immigration law, such as overstaying, breaching visa conditions, or entering illegally, an application can be refused. Refusal is mandatory if the application is made within a specified re-entry ban period, which ranges from 12 months to 10 years, depending on how the person left the UK or whether deception or removal was involved. Outside of those periods, refusal is discretionary. Certain periods of overstaying can be disregarded, including short overstays, late applications with good reason, overturned refusals, and specific COVID, BNO, or exceptional assurance concessions. If you'd like more information about the UK spouse and partner visa requirements, or if you'd like help with your application, you can visit our website www.migrate.org.uk.